Hello, and welcome to Sears Wardle webinar on third-party contractors. My name is Mary Dahl, and I'm a partner here at Sears Wardle. I'm here today to discuss third-party contractor liability. What are third-party contractors? Some of the more common ones I have listed are landscapers and snow removal companies. Lawsuits against snow removal companies, especially here in Michigan, generate a lot of opinions from the Court of Appeals with regard to whether they adhere to the terms of the contract, which generally have requirements as to the laying of salt and plowing of snow when there is a certain amount of snow or precipitation to trigger the contract. But before you get to an actual judgment, the plaintiff must first show negligence, as everyone knows. So you must first establish duty. And that is where we go when reviewing a third-party contract. What were the duties of the parties that entered into the contract, and who were the parties? The duty in a premises liability action arises out of either a statutory duty, which you could find in a tenant-landlord situation, or a contractual duty, which is the basis generally for third-party contractor liability, and of course common law duty. A third-party contractor case will usually be a contractual one arising out of the contract between the premises owner and the snow removal company. So what is the duty of a third-party contractor? Well, we have some case law which we generally turn to in determining the duty of the contractor. First, we have Derbabian versus Mariners Point. The court held in Derbabian, where the defendant was a snow removal contractor, that the defendant had no common law duty to inspect or salt the parking lot. The Court of Appeals held that the defendant did not breach the duty of care when it failed to inspect the lot on the date in question. The plaintiff did not have an independent tort action against the defendant third-party contractor, i.e. the snow removal company. So there is a distinguishing element as to misfeasance and nonfeasance, which was discussed in this case by the Court of Appeals. Nonfeasance is the failure to perform a contractual duty, whereas misfeasance is an active, negligent act in failing to perform a contractual duty by actively causing a danger. This distinction becomes an integral part of later cases. Next, we have the Fultz case, which is always cited in third-party contractor matters. This is a notable decision by the Supreme Court. The plaintiff has slipped and fallen on an icy parking lot, which the snow removal company had been contracted to keep clear of, ice and snow, and allegedly failed to salt. The Supreme Court found that the misfeasance versus nonfeasance analysis discussed in Derbabian was too slippery a slope. So the court looked at misfeasance as a separate action distinct from that of any contractual duty. The Supremes found that there was nonfeasance in Fultz as opposed to misfeasance, but the court did not provide a detailed analysis of this separate and distinct approach. The court, however, stated that since the plaintiff's tort claim was based on defendant's failure to perform its contractual duty of plowing and or salting the parking lot, the claim failed under this separate and distinct analysis. The plaintiff's cause of action against a third-party contractor was then dismissed. Going forward from Fultz and its progeny, the court has taken some leeway with its Fultz decision, and I add to this slide also the Banasek and the Mazursky case. In Banasek, the third-party contractor was Otis Elevator Company. They were contracted to install elevators and moving walkways at Metro Airport. They were required to cover a wellway, which held the mechanical equipment for the walkways and was at the end of the moving walkway. Plaintiff, however, was injured when she stepped on a piece of plywood that was acting as a temporary cover for the hole. According to the Supreme Court, the wellway was the subject of the contract between Otis and the airport, so Otis owed no duty to the plaintiff that was separate and distinct from the duty under the contract. Even though Otis clearly increased the danger to the plaintiff or otherwise created a misfeasance, The court held that there was no distinction between the misfeasance and the nonfeasance, so there was no breach of a duty separate and distinct from the contract, which is in sharp contrast to the Fultz progeny. Similarly, in Mazursky, which was later rejected in Lewicki, which I will discuss later, the defendant created a misfeasance by piling the plowed snow from a parking lot onto a landscaped, curbed island in the parking lot. The argument was then that this action created a new and dangerous hazard because of the melting and refreezing of the piled up snow. Again, the Supreme Court rejected the argument that the plaintiff was owed a duty separate and distinct from the contract, even though, similar to Banatek, there was a misfeasance or the act of creating a more hazardous situation as opposed to a nonfeasance. So we come to the Lewicki decision, which overruled both Banasek and Mazursky, and also modified post-Fultz decisions, which tried to do away with separate and distinct duties regarding misfeasance. In Lewicki, the accident occurred at a construction site, where the plaintiff was working for an electrical subcontractor. The defendant's employee left a bunch of cement boards stacked against a hallway, which then fell upon the plaintiff and injured his leg. The Supreme Court rejected the Court of Appeals and found that Fultz did not distinguish the simple idea that is embedded within the American common law of tort. If one having assumed to act does so negligently, then liability exists as to that third party for failure of the defendant to exercise care and skill in the performance of the act itself. Fultz did not extinguish that common law duty, such as the duty to use ordinary care to prevent harm to foreseeable persons or property. Rather, the court found that the initial inquiry, aside from the contract terms itself, should be whether there is an independent legal duty to the plaintiff. Contracting parties do not extinguish or limit separately existing common law or statutory tort duties owed to a non-contracting third party in the performance of its contract. So essentially, Fultz was brought back to its original and primary holding by the Supreme Court in Lewicki. The difference between a nonfeasance and a misfeasance, and whether a person who is not a party to the contract can then sue for a breach of that duty for a misfeasance. So then we got to Hill versus Sears in 2012, which was heard by the Supreme Court. In this case, the issue focused on whether an appliance repairman from Sears had a separate and distinct duty from the contract to install appliances. In Hill, the plaintiff had purchased a washer-dryer from Sears. The installer came out from Sears. There was apparently an uncapped gas line in the area. The court said that due to the limited relationship between the installers and the homeowners, they did not have a duty to take any action with respect to the exposed uncapped gas line, nor did Sears have duty to warn the homeowners of the uncapped gas line. The installer did not create a new hazard by placing the dryer in front of the uncapped gas line. The Bailey case is an odd case. It is a 2013 case, and I included it because the court remanded it back to the Court of Appeals to determine what the security company's duty under Lewicki was, and with clarification from Fultz as to the nonfeasance versus misfeasance argument and a separate and distinct duty to the plaintiff. The Supreme Court examined whether the third-party contractor, who was a security company called High Tech, which was hired to patrol the premises in Bailey, was under a duty to the plaintiff to provide security services for the premises owner. Apparently, the plaintiff ended up being shot and paralyzed at an outdoor event at the premises' common area. The Supreme Court focused on the landlord management duties to the plaintiff so as to notify police if given notice of a dangerous or criminal activity on the premises. The Court of Appeals originally found that the contract between High Tech and the landlord would impute the landlord with notice of the criminal situation. The landlord then had a duty to inform the police. However, when the case got to the Supreme Court, the justices felt that the matter should go back to the Court of Appeals for a consideration of the nonfeasance versus misfeasance under the Fultz and Lewicki decisions to determine whether there is a duty on the part of High-Tech. The Court of Appeals then decided that High-Tech had no duty to protect the guests, and their claims against High-Tech were dismissed. However, the claims against the landlord were not. The court found that the landlord had a duty to protect the guests from the criminal acts of third parties when it had notice of a specific situation that would cause a reasonable person to recognize a risk of harm to an invitee. Finally, and most recently, the Sixth Circuit chimed in with the case of Leone versus Bmi Refractory. In Leone, which is a published case from 2018, the panel dealt with the question of whether the duty of care extended to a third party who was not a party to the contract. The court ruled that the duty of care did extend to the plaintiff because of separate and distinct obligations outside of the contract. The court concluded that the lower court applied Michigan law too narrowly, mistaking a, quote, common feature of Osmond, David, and Lewicki, which was the defendant's creation of a new hazard, as a requirement, end quote. The Sixth Circuit stated that when BMI performed its contract, it assumed to act, thereby taking on a duty to perform that action in a non-negligent manner. Once the duty was established, the defendant had to act with due care or as a reasonable person would under the circumstances. Courts presented with the Fultz defense begin their analysis with an inquiry as to whether the defendants owed the plaintiff any legal duty that would support a cause of action in tort, whether that is a common law or a contractual duty. By Lewicki and Bailey, the door seems to be opening for persons to argue that they are owed an independent common law duty of ordinary care. So as I stated in this slide, if a third-party contractor performs an act, it must do so reasonably, which in essence returns the standard governing a misfeasance versus a nonfeasance. So a third-party contractor's failure to act, despite a contractual duty to do so, will not establish liability. However, unreasonable actions, regardless of the contractual language, will impose a duty on a third-party contractor, such as creating a new hazard or danger by its actions or inactions. Lastly, I wanted to address the open and obvious defense as it pertains to third-party contractors. The open and obvious defense is commonly used in slip and fall, trip and fall cases, and was made famous by the decision in Lugo. Can it apply, however, as a defense in a third-party contractor situation? Probably not. In Ghaffari v. Turner Construction, the Supreme Court held that open and obvious defenses do not apply as it is specifically applicable to a premises possessor. In Ghaffari, plaintiff was a subcontractor working for the defendant, so not like the normal scenario where an invitee would slip and fall on ice or trip on a sidewalk. The plaintiff in Ghaffari tripped on some pipes in the ground. The Court of Appeals applied the open and obvious defense and dismissed all of the plaintiff's claims. The defense bar cheered. The Court of Appeals said there was nothing to suggest in the open and obvious doctrine that it would be restricted by its applications. Plaintiff then took the matter up to the Supreme Court, who reversed. Again, the defense bar booed. The court said that the doctrine was specifically applicable to the premises possessor. The law is unlikely to change in the near future with the current bench. This concludes my presentation on third-party contractors. Thank you for your time. If you have any questions, I am located in the Troy office, and my direct line is 248-539-2824. Or you can reach me by email at mdahl@seacrestwardle.com.